Welcome, and thank you for joining Part 3 of Seyfarth's micro-webinar series, Workforce Realignment and Reductions in Force. This installment of the series will focus on WARN Act issues. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Allison Silvera. Allison, you may begin.
Thanks, Brooke, and thanks for joining us, everyone. I'm Allison Silvera, partner in the Labor and Employment Group of Seyfarth's Boston office, and I'm joined today by Chris Kelleher and Alex Reganata, two of the associates on our team. Next slide, Brooke. And the next one. So today we're going to be talking about the Worker Adjustment and Retraining Notification, or WARN Act, and providing everyone with an overview of when the act is triggered and what it requires. The goal of today's webinar is to help you issue spot circumstances when WARN may be triggered, but not to provide an in-depth examination of its requirements. Next slide, Brooke. So I think typically when people think of WARN, they think of it as limited to labor relations, a statute that requires notice to unions or of information that may impact the future employment of their members. But WARN is actually much broader than the labor law context. The Federal WARN Act requires employers to provide 5 different categories of people with at least 60 calendar days of advance written notice prior to any covered plant closing or mass layoff occurring at a single site of employment, as those terms are defined in the statute. The people who have to get notice are all affected non-union employees, union representatives of affected employees, the dislocated workers unit of the state in which the affected employment site is located, the chief elected official of the municipality in which that site is located, and the chief elected official of the county in which the site is located. But not all workforce reductions, even significant ones, are WARN covered events. And I'm going to turn it over to Chris to give us some further context for when the WARN Act is actually triggered. Go ahead, Chris.
Thanks, Allison. We can move to the next slide. Brooke, thank you. So in this section, I'll be talking about largely which employers are covered and which events trigger WARN obligations. So in terms of employer and employee coverage, as Allison mentioned, not all employers are covered. And as we'll get into in a minute or so, not all events trigger WARN obligations. Generally, when it comes to employer coverage, employers are covered under WARN if they have 100 or more employees, and that is not counting employees who have worked less than 6 months in the last 12 months, and also not counting employees who work an average of less than 20 hours a week. So oftentimes in the regulations and interpretations of WARN, you'll see the term full-time employees, and that's generally an employee who works more than 20 hours a week for WARN coverage. So small employers may very well be excluded from coverage under WARN. The business has to employ at least 100 full-time employees or the hours equivalent across all of its facilities. So this means a national employer might be subject to WARN because it has more than 100 employees across all of its facilities, but when it comes to a local plant shutdown or a local layoff, WARN might not kick in. WARN does apply in most situations where a reduction or may apply when reductions in force are considered, mass layoffs, furloughs. Unfortunately, we all had to go through a lot of this in the early stages of the COVID pandemic, it covers many different types of employers, including private for-profit employers as well as private nonprofit employers. It can also apply to quasi-public entities that operate in a commercial context and are separately organized from the regular government. So you might be thinking telephone, gas, utility type companies. However, federal, state, local government entities that provide public services are not covered by WARN. In terms of employee coverage, most employees are covered, hourly and salaried employees, as well as managerial and supervisory employees. Who is not covered? There's a carve-out for strikers or employees who have been locked out in a labor dispute. There's also carve-outs for business partners, certain consultants and contractors who are not technically employed by the location, by the plant or facility. And also there's a carve-out, of course, for regular federal, state, and government employees. Next slide, please. So what triggers WARN notice? There are two main triggering events, and that's mass layoff and a plant closing. And we'll discuss a few nuances to this as well. But a mass layoff is when a covered employer needs to give notice because there's a layoff that it doesn't necessarily result from a plant closing, but it will result in employment loss at a single employment site during any 30-day period of 500 or more employees, or for between 50 and 499 employees if they make up at least 33% of the employer's active workforce. So that's a little bit of a mouthful. So to qualify for a mass layoff, an employer must lay off for at least 6 months or discharge at least 50 full-time employees, which are defined under WARN, as we discussed, as employees who work more than 20 hours a week, at the employment site, with those employment losses comprising at least 1/3 of the full-time workforce at the location in any 30-day rolling period. So for example, if there's a facility with 300 full-time employees, at least 100 employment separations would need to occur, and that's either 6-month layoffs or more, or permanent discharge, or whatever it may be. Alternatively, a mass layoff would occur regardless of the percentage of the workforce if at least 500 employment losses occur at a single site within a rolling 30-day period. So that's mass layoff. A plant closing, in a plant closing situation, a covered employer needs to give notice if an employment site or one or more facilities or operating units within the site will be shut down, and the shutdown will result in employment loss of 50 or more employees during any 30-day period. So again, when we're talking about mass layoffs and plant closings, this doesn't count employees who have worked less than 6 months in the last 12 months, or employees who are not full-time, meaning they work an average less than 20 hours a week. So to recap in terms of plant closing, even if there's no mass layoff, a plant closing under WARN occurs if at least 50 full-time employees at a site experience an employment loss within any rolling 30-day period, and those losses are the result of closure or substantial closure of the site, a building on site, or one or more of the departments. So you can't necessarily avoid liability here by maintaining a skeleton crew, for instance. Importantly, the mass layoff and plant closing tests have an alternative 90-day employment loss aggregation test, which provides that if the employer does not have enough losses at the site within any rolling 30-day period to trigger the statute, but it does have enough causally related losses within a 90-day rolling period, there is a WARN event. So there's an aggregation piece that you should be thinking about. If there are employment losses that don't necessarily happen in that 30-day period, but happen near that period, that might be related to the triggering WARN event. So in this case, job losses within any 90-day period will count toward the WARN threshold level unless the employer demonstrates that the employment losses during that 90-day period are the result of separate and distinct actions and causes. And in the parenthetical here, beware of hours reduction. So there's another potential triggering event under WARN, and that's where a reduction in hours of work for 50 or more employees by at least 50% in each month of a 6-month period, that does constitute an employment loss and will trigger WARN obligations. Some states, this presentation is largely focused on the federal WARN Act, As some of you may be aware, there's a good number of states that have state-specific WARN requirements. We won't be getting into that specifically today. Alex will mention them in a few minutes. We won't be getting into detail on that, but just know that they're out there, and some states may find employment loss has occurred with a smaller or shorter number of hours reduction. So to recap the thresholds and sort of give you a sense of when WARN is not triggered, because it's often not triggered. WARN is not triggered when the coverage thresholds that we've just described are not met. So if a plant closing or mass layoff results in fewer than 50 people losing their jobs at a single site of employment, if between 50 and 499 workers lose their jobs, and that number is less than 33% of the total active workforce at the single site, if a layoff is for 6 months or less, or if work hours are not reduced by 50% in each month for any 6-month period. So if these coverage thresholds and triggering events are not met, you don't have WARN obligations. Next slide, please. There are a couple defined terms that I was throwing out there when I was going over mass layoff and plant closing that I'll just address here. Employment loss is an employment termination other than a discharge for cause, also a voluntary departure or retirement. It's also a layoff exceeding 6 months, as we discussed, and a reduction in employees' hours of work of more than 50% in each month for any 6-month period, as we discussed. So that's a defined employment loss term. With regard to discharge for cause, employers should be cautious in not counting these terminations in determining the coverage thresholds and triggering events, because the employer may need, if it's scrutinized, the employer may need to show that the discharge wasn't an attempt to evade the WARN Act. So just need to be a little bit careful there. And there are exceptions to the employment loss definition. So an employee, in certain circumstances, if an employee refuses to transfer to a different site within a reasonable commuting distance, in certain circumstances, that person does not experience an employment loss. In other circumstances, an employee who accepts a transfer outside this distance within 30 days after it is offered may not experience an employment loss. So there are exceptions where transfer is involved, but with respect to those exceptions, the offer to transfer must be made before the closing or layoff, and there must be no more than a 6-month break in employment. So it's a little bit of a nuanced scenario there, something definitely to look into if you're considering a WARN event. And the single site of employment, typically we're talking about a single location, but a single site can include, for instance, a group of structures on a campus or an industrial park, or even separate facilities that are across the street from each other. There's a little bit of a fact-intensive analysis that goes into the single site of employment, but typically we're talking about, a commonly understood single site of employment. Even if an employer is large enough to potentially be covered by WARN, as I mentioned before, the statute looks at the number of full-time employment losses that occur at this site, not at separate sites. That's an important thing to know. And the point in time that we're counting employees is typically either a 30 or a 90-day period. The single site of employment requirement means that even if a large national employer were forced to lay off a few employees at many different locations, WARN would not be triggered. So it's important to remember these triggering events. And an interesting scenario that's arisen certainly in light of the pandemic and the shift to remote work. What site does a remote worker work at, and how to count them for purposes of determining numbers of employees? And for WARN purposes, employees who work at home or remotely, or even salespeople or traveling individuals, are typically cited at the brick and mortar employer location from where they are supervised, where they report, or where they are allocated within the employer's self-organization. So the single site is typically the home base, the place from which work is assigned, the place from which they report. Next slide, please. So as Allison mentioned at the top, the WARN Act requires notice, and here on this slide you can see that notice must be at least 60 days in advance in most cases. It must be written, and it must be distributed to not only the employee, but various other individuals, entities, and offices, which I'll get into in a moment. But, you know, why should employers care? Why should they comply? The statute does have some teeth, and there are repercussions for violations. So in terms of liability, for failure to give notice or failure to give appropriate notice, liability can include back pay, benefits, out-of-pocket medical expenses for affected employees for up to 60 days, potential civil fines, and the statute also allows for attorney's fees in case of WARN violation. WARN litigation is susceptible to class actions, and unions typically have standing to bring WARN class claims on behalf of their bargaining unit members. So there is some significant potential liability for violations. Next slide, please. Who needs notice? Of course, the affected employee needs notice, the union representative if the employees are represented by a union, the dislocated worker unit of the state in which the affected employment site is located. So most states have this. In Massachusetts, it's called the Mass Hire Department of Career Services Rapid Response Team. And what they'll do when they receive notice is they'll attempt to coordinate with the employer to provide information to employees, whether it's on-site or electronically, about employment, retraining services, help them find new jobs, that type of thing. Notice must also go to the chief elected official in the municipality or county. Typically, we're talking about the mayor. It could be in various types of municipalities. It could be the municipal board, whatever it may be. So these are the individuals and entities who need to receive that notice. And the same notice can typically be utilized to comply with most state WARN type statutes, but as I mentioned, we're not going to be doing a deep dive on state WARN, so you want to obviously check with your council in terms of local state level WARN requirements. Next slide, please. The form and content of the employee notice. So notice will differ depending on who you're sending it. It will slightly differ depending on who you're sending it to. For purposes of the impacted employees, it must contain a statement as to whether the planned action is expected to be permanent or temporary, and if the entire plant is going to be closed, a statement to that effect. The expected date when the plant closing or mass layoff will commence, and the expected date when the individual employee will be separated. An indication whether or not bumping rights exist, and the name and telephone number of a company official to contact for further information. So even if you've made it clear that a separation will occur, that a WARN event will occur orally, it doesn't matter. You need to go through these steps. It's not that difficult to achieve compliance. You need to issue these notices and make sure it's on time and all that. Have to have the magic words and the magic categories. So even if you've orally discussed this with employees, this written notice needs to happen. And bumping rights, for any of those who don't know, it's typically in a collective bargaining environment. You need to notify employees if they have the right to displace others in terms of the layoff list. That would be usually defined in a collective bargaining agreement or in other employment policy or agreement. There's no required method of delivery. So WARN notices can be delivered in person, through mail, certified or registered mail, overnight. It doesn't matter, but it needs to be calculated to get it to the employee within 60 days. Those notices are effective upon receipt, not upon mailing. So you probably want to, if you're going to be mailing it, you want to mail it in advance of that 60-day period. Typically, courts will recognize the 3-day mailbox rule. So if you mail it 63 days in advance, typically you're covered. The notice to the state rapid response team, as I mentioned, and to the chief elected official will be slightly different contains much of this information and a little bit more. There's also an option to provide more limited information to those state entities, but you need to keep all of the information to have it available if they request it. So that's the notice, and I think Allison in the next section is going to be discussing exceptions. I think you're on mute, Allison.
Thanks, Chris. I was just saying I had a flashback to law school when you referenced the mailbox rule.
Yeah.
All right, so there are a handful of exceptions to Warren's notice requirements where notice either is not required at all or where it can be given with less than 60 days advance warning. So let's go to the next slide, Brooke, sorry. As far as the exemptions, so where notice is not required at all, there are 3 scenarios, Chris touched on them, where you are not required to send notice. First is if the closing of a temporary facility or because of a project having been completed. In those circumstances, notice is not required so long as the impacted employees were hired with the understanding that their employment was limited to the duration of the facility, the project, or the undertaking. But I would note with respect to this exemption, the DOL is aware of the potential abuse and has been very clear in its fact sheet that an employer cannot label an ongoing project as temporary in order to evade its obligations under Warren. The second situation is strikes and lockouts. So this may be very relevant in the current job market, given what's going on with industry-wide strikes at the moment. But an employer does not need to provide notice to strikers or to workers who are part of the bargaining units, which are involved in labor negotiations that led to a lockout, when the strike or lockout is the equivalent to or creates a situation that's the equivalent to a plant closing or mass layoff. The caution in this scenario, though, is that impacted employees who are not on strike or are not part of the strike bargaining unit involved in the labor negotiations that led to the lockout are still entitled to notice. And then the third situation is if the plant at issue is relocating to a different location that's within a reasonable commuting distance to the facility that's closing, and the impacted employees are, prior to the closing, as Chris mentioned, offered a job at the new facility, they're not required to get notice if they decide not to accept that job. Next slide, Amy. Or Brooke, oh my gosh. So the next situation is there's 3 circumstances under which an employer is not required to give the full 60 days of notice. And these circumstances still require that notice go out, but you can still be in compliance with Warren so long as the notice contains a statement of the reasons for reducing the notice period, along with all of the rest of the required information. So the theme in each of these scenarios is that it was unforeseeable and out of the employer's control. An employer was unable to secure new capital, unforeseen business circumstances, for example, an unanticipated or dramatic major economic downturn, or a government ordered closing of an employment site without prior notice, or of course a natural disaster. All of those are unpredictable. And while you may still be required to give Warren notice if there's going to be an impact, you would be relieved from the 60-day requirement so long as you meet the unforeseeability requirement. Next slide. So the next 2 slides are 2 sort of frequently asked questions that we get about the implications of Warren. The first question here is, what if I don't know how long a layoff will last? Whether you need to give notice in that situation is based on the best available information to the employer at the time. So if the employer, if at the time of a layoff, an employer, based on the best information available to it and exercising sort of commercially reasonable judgment, concludes that a layoff will not last at least 6 months, it will not have to provide Warren notice at that time. But as these are fact-intensive considerations, there's always a risk that retrospectively you'll be deemed to have reasonably been able to foresee a layoff of more than 6 months. And notably, as soon as you realize that an employee is going to be laid off for more than 6 months, you should give the Warren notices as soon as possible, while presumably invoking the unforeseeable business circumstances notice sort of reduction that we talked about on the last slide. Next slide. So the second question that we get a lot is, what if I announced a Warren layoff or plant closing, but that date is going to be delayed? In those circumstances, if certain employees will need to be retained beyond the dates of separation announced in the initial Warren notices, supplemental notices may be required under WARN. So the DOL's applicable regulations address postponement of previously announced closing dates. If a closing date is extended more than 14 days after the initially planned date, but is for less than 60 additional days, you can provide a supplemental notice, which would just let the impacted employees know of the postponement and the reasons for postponement. But if it's extended, if the date is extended for more than 60 days, the additional notice should be treated like an entirely new notice. Next slide. Chris and I have a little bit of duplication here, but I thought it was important to just reiterate and circle back to where we began the presentation. WARN is a notice statute. It's not a payment of wages statute. It's not a late payment of wages statute. And that said, as Chris has already mentioned, there are wage-related penalties for failing to comply with WARN, the most relevant of which is that an employer who violates the provisions by ordering a plant closing without providing the right appropriate notice will be liable to each aggrieved employee for back pay and benefits for the period of violation up to 60 days. This is a little bit beyond the scope of this presentation. I know there are states that allow you to pay in lieu of notice. There are states that prohibit pay in lieu of notice. So if you're thinking about providing pay in lieu of notice, it's pay and benefits. And you should talk to a counsel in the jurisdiction that with the impacted plant to make sure that that's okay in the state where the impacted location is located. There's also the civil penalty Chris mentioned and enforcement. The biggest risk with enforcement is that the workers or their unions can bring individual or class action lawsuits in courts. Before we go on to the last section, I just want to announce the CLE code for today's webinar. The code is SS as in Seyfarth Shaw 3147. So it's SS 3147. And then in the last few minutes, I think we just have 2 or 3 minutes left. I'm going to turn it over to Alex to just highlight the states with WARN statutes that we want to make sure are on your radar. Alex?
Thanks, Allison. And we can go to the next. Yes, that's right where we should be. Thank you, Brooke. And as you've heard Allison and Chris kind of go over so far, there's triggering thresholds, there's various different effects that the WARN Act is going to have on a business who's starting to go towards a employment loss. But that's all under the federal WARN Act. Each of these states that you can see here that have been highlighted in a color other than that light blue is going to have their own state-specific WARN Act. Pennsylvania is slightly different in that Philadelphia has a local WARN Act, but the state of Pennsylvania does not. And so if you're in any of these states with a bubble that's been colored, you'll probably want to make sure that you're being extra cautious if you're approaching any of those situations that both Allison and Chris had talked about. And we're going to talk a little bit about a few of the New England states. Brooke, you could take us to the next slide. We'll also be distributing this after the presentation, so you'll have this information and you can refer to that helpful infographic as necessary. So New Hampshire is one state that's going to have a different triggering threshold than the federal WARN Act. It's going to be looking to see if there was 25 employee loss instead of 50, which is where the federal WARN Act had kind of drawn the line. Maine is going to impose a 90-day notice requirement, and there's going to be some mandatory severance requirements, and that's usually going to be about 1 week of pay for each year of employment. And they're going to have some requirements requiring partial pay if there was a partial year of employment for that employee. There are some exceptions there, but that's getting a little too into the nitty-gritty. Massachusetts is a little strange. It does not have a WARN Act, but it has plant closing laws. Now, the experience has been that this is not heavily enforced, and we've included a link to the Massachusetts government website that you can go and explore yourself. But of course, you should still always explore this act and any others with legal counsel before making any business decisions. There's many other provisions that are going to be state specific, but there's too many to get into for the purposes of this presentation. So as always, be cautious and call a Seyfarth attorney.
Thanks, Alex. And Brooke, if you can just go to the last slide. We just wanted to remind everybody that today's webinar was part 3 in a 4-part series, and the next part is going to be about using AI and technology in connection with reductions in force. That's going to be led by Barry Miller and Molly Mooney on October 18th. So keep an eye out for the invite for that presentation. And otherwise, we're going to end right on time. Thanks everybody for coming. I saw one question in the chat. If there's any more, we'll get a report afterwards and follow up. Thanks everyone.
Thank you.